We also are joined by Mr. Ajit Kumar Mishra. He is based off India and comes from Ircon International Ltd, a Government of India Undertakings director works. Mr. Ajit Kumar Mishra is an infrastructure contracts specialist and director on the board of Ircon International Limited, an Indian public sector enterprise executing projects across more than 25 countries. He previously led the contract management division of a USD 12 billion World Bank and JICA-funded rail program overseeing dispute resolution under FIDIC-based contracts. With over 3 decades of experience in infrastructure delivery, public procurement, and international dispute resolution, he regularly serves as arbitrator, adjudicator, and mediator in domestic and cross-border matters. He is a FIDIC President's List adjudicator and certified trainer, reflecting his expertise in FIDIC contract frameworks. He is a fellow of the Chartered Institute of Arbitrators. He is empaneled with multiple international arbitration institutions and serves as vice chairman of the Society of Construction Law India and delegate to the ICC Commission on Arbitration and ADR, contributing to scholarship and professional dialogue on international construction arbitration. Thank you for being here, Mr. Ajit.
Very good afternoon to all of you, and welcome to this presentation on energy disputes. Dendi had just now covered the mining disputes, and I have been tasked to deliver and discuss on energy disputes. The nature of these two disputes, although both mining also ultimately results into some sort of energy, but the nature of disputes are slightly different, which I'll be coming down and explain a little while later. But my presentation on energy disputes, I have divided it in 5 sections. The first, I'll be briefly touching on the nature of energy disputes, how they are different from other kind of disputes. And then I'll be briefly touching about the global energy disputes, which have really shaken the world of disputes. And 3 jurisdictions I would like to touch where some landmark decisions have been made in the past. And then I'll suggest a way out how to handle efficiently your energy disputes. The first part of my topic is about the nature of energy disputes, and where I'll be highlighting the 8 distinct features for energy disputes, which segregates this kind of dispute from other kind of disputes. Starting with, let me bring home a concept that energy disputes are generally work under dual legal framework. At one part, it deals with the commercial disputes, and on the other part, it deals with the investment related disputes also. So you may have your arbitration as a commercial arbitration, and at the same time, you may have a commercial related to or arising out of investment treaties. Another distinguished feature for this energy sector, and particularly when it is coming out of the investment treaty part, is that there could be a pervasive role of a state where it could act as regulator, licensor, tax authority, or any other different role. And considering the geopolitical situation currently, and even in past that has been so volatile, this could be one of the biggest risk in this kind of dispute. Another distinguished feature is about the resource nationalism. And as you know, the energy is generally is linked with the natural resources of the nation, and there are different policies to control the natural resources of a state. So the state intervention could be a very important and prominent factor in this kind of disputes. The scale is huge. The size of disputes or the size of projects are huge as compared to any commercial contracts or disputes arising out of that. There could be sector specific contracts, and it's not so, because even in construction contracts, you could have your sector specific contracts. But here it is more nuanced one. And distinguishedly, there are not many standard contract forms to help you out or guide you in say, for example, preparing your bid document or preparing your concession agreements or something like this, because every project is a separate, completely nuanced, distinguished concept. So you have to work in from de novo. You don't have much of the precedence to help you out. Then there could be a unique kind of dispute, which are energy transition disputes, and where there could be reversal of incentives. There could be phase out of your nuclear power plant agreements, and then there could be adjustments in grid concessions and grid supplies arrangements. So these are typical nuanced one specific to this sector. The valuation, if you have a dispute and how to quantify that dispute, is a little bit difficult in this kind of disputes, because in all these disputes, what you claim is your loss of future earnings. And as the time frame of these contracts are long, 30 years, 40 years, it is difficult to assess how in next 30 years you would have lost your earnings, or how to calculate, assess your damages. The most widely used discounted cash flow formula, DCF formula, has their own limitation and may not reflect what you were actually losing. Then confidentiality part, the technologies are distinct, unique, and brand is specific, or the supplier is specific. And so their nuances are different and separate. Let me highlight this sovereign state risk in little bit more detail. The types of state intervention could be manifold. There are different types which have been explained also in investment treaty documents. The first one could be the direct appropriation or nationalization. For example, to give you the example, in Venezuela, Chavez nationalized Orinoco Belt in 2017. It's a example of direct appropriation. In Russia, Yukos, the case which I'll be discussing subsequently also, the punitive taxation regime to destroy the political opponent is kind of indirect expropriation through fiscal or financial measures. Next example is in India, the Kayan's case, where retrospective tax amendment led to huge financial repercussions, and this was in the breach of fair and equitable treatment for the investment. There could be examples of license revocation and export restrictions, which nowadays you see the very common the tariff war which is going on in current geopolitical situation is one way of this state intervention. Then there could be forced renegotiation of concession terms. The glaring example is a case of Mali, where physical seizure of gold and detention of executives were done to negotiate the different terms and some kind of, so this is one way of forced negotiation. Yes, Mali is a glaring example. And coming to the resource nationalization aspect, uh, I just gave you the examples of Mali, where then in your country, in Indonesia, they could the critical mineral exports control uh, are ruling this resource nationalization aspect. The mining code revision and mid-term concession is could be one possible intervention. Geopolitical sanctions, I just told you, is now in current geopolitical situation. In contrast, the construction contracts are much simpler. The employer's powers are bounded by the contract in the four walls of contract. But in energy, the state can legislate, tax, regulate, and nationalize. So the state plays a very broad and deep role in these kind of contracts or concessions. See the scale and quantum and the duration which has been taken in dispute resolution. The first example, which no one will ever forget, is the UCOS versus Russia example. And the claims awarded by the tribunal is 50 billion US dollars. Although this is still under dispute, it has not been closed, but the dispute first arose sometime in 2003, and it's 2026, it is still running. The another big example is ConocoPhillips versus Venezuela. The annulment was rejected last year, and the amount involved is 8.7 billion. The another big example is a Spanish renewable case. In this case, 50 plus energy charter treaty cases have come up and still running. Indian example about the Cannes case, where the 1.2 billion US dollar claims have been concluded now because of this retrospective tax reversal. Let me slightly touch on the difference between energy and construction dispute, how structurally they are different. The parties, as far as in construction, it is only employer versus contractor. There may be some subcontractors, consultants, but they are very clean and clear party identification in this case. But in energy, the contracts are generally between private investor and sovereign state. So you see there is a structural asymmetry, where construction contracts, the parties are treated at par. But in this case, the private investors and sovereign state, they have their own different power dynamics. Though there are different concepts to deal with this inequality, and those are working well also, but when the equations gets distorted, the parties suffer a lot, both state and private investors as well. The legal basis of construction disputes are rather simpler. It deals with the breach in the contract, then change in scope, some variation, delays, defects. Those are rather not that much nuance. I'll say that in big construction contracts, they have some role, but not as complex and as costly as compared to the energy disputes. The legal basis are arising out of treaty and contract. Then there are different concepts like fair and equitable treatment, expropriation of assets by state, then legitimate expectation of the party. These concepts are much nuanced in this kind of investment disputes. The deal with disputes of a construction contract is again well legislated in your contract itself. You could have your multi-tier dispute resolution process. But in energy, and investment disputes, the concepts are not that well legislated, and there could be, whether you are seeking local remedy or you are going for the direct arbitration, the which forum you are selecting. The Dendi was talking about the forum selection, whether you are picking ICSID or permanent court of arbitration, which one. It's all rather fluid in this case, and this causes complexity in handling energy disputes. Enforcement is another painful and, most importantly, very long process. So, construction and commercial contracts, we have very well incorporated New York Convention, which has been ratified by several countries, over 100 countries. But in investment and energy disputes, the concepts like sovereign immunity, asset shielding, these concepts come into play, and that makes the dynamics more complex. And even for very experienced, seasoned counsel like Dendi and his corporate team, these are difficult to handle. I'll pick up few landmark energy disputes, and as I was mentioning, is the UCOS versus Russia. The biggest arbitral award has ever been issued in this case, is a 50 billion award, and the award has been issued long back in 2024, but it has not yet been enforced. The dispute was simple. The Russia expropriated UCOS through punitive taxation, selective prosecution of the owners, and forced asset sale to a state-owned company. The tribunal found these actions unlawful under Energy Charter Treaty. The enforcement, the award creditors have tried to enforce the award in several countries, and in Netherlands, it has been upheld in 2024. England has also has rejected the estoppel, or rather upheld the estoppel. In Singapore, immunity has been rejected. USA has also remanded it, and very recently, last month also in UK, this estoppel has been again validly upheld. So, but still, as far as you say that whether the money or that has been paid to the aggrieved party or not, the answer is no. It is still in the legal field. So 2003 and 2026, it's still in process. Another important dispute is ConocoPhillips versus Venezuela. And in this case, Venezuela nationalized Petrojua, Hamaca, and Conoco offshores in 2017. Expropriation was held unlawful under Netherlands Venezuela BIT. Award was issued. ICSID committee has rejected on all grounds. Award was fully upheld, but there is a parallel proceeding which had been settled in August 2018. Spanish renewable, 50 plus cases arising out of this ECT. In the latest scenario is that Spain refuses to pay the ECMIA defense. The case is still ongoing. In India, we have this Dabhol and Roll case. It was a power purchase agreement. The dispute ran from 1992 to 2006. The bullets highlighted here reflects the distinguished risk which you have in this kind of dispute. as there is a political risk project cancelled after 1995 elections where the state party, there was a change in political leadership of this state, and that led to forced negotiation, which I was talking about the Mali. It was almost similar situation here. There was failure of power purchase agreement. The tariff was revised, and it was made 20x from the what has been agreed originally. There was default from sovereign actions. The Government of India counter guarantee deemed expropriatory by arbitral panel by issuing the award. There was stakeholders opposition. This could also happen in many of these projects, especially the long-term projects. And as they deal more and more with the public environment, this risk is more obvious and more prominent. The human rights activists were very much active on this project, and they led to severe disruptions in the smooth conduct of this project. There was corporate collapse. Enron entered into bankruptcy in 2001. There was multi-forum litigation, OP claims, ICC arbitration, and all. So this, once the project gets derailed, it's very difficult to control and really harp the intended benefits out of this project. So this case is a failure of contract design, political risk assessment, and tariff sustainability. This is a very strong lesson which you must have when you are designing your energy and power purchase agreements subsequently. If you have a dispute, and it largely matters in which jurisdiction you are and with which jurisdiction you are dealing with. Dendi briefly touched about it, and for example sake, I'll be covering 3 jurisdictions: India, UK, and Singapore, and they cover largely your jurisdiction as well. Cairns Energy, I was discussing, where a dispute that changed tax policy. In 2012, a retrospective income tax amendment was issued, and it imposed a capital gains tax on Cairns 2006 restructuring. So this retrospective tax policy was having effect as back as 6 years, and the tribunal found the violations of fair and equitable treatment under India-UK BIT. When award went for the enforcement efforts were made in US, UK, Canada, France, Singapore, Mauritius, UAE, and many other countries wherever the Indian assets were there. French court order was interesting. In their 20 Indian properties were seized. In US, Air India sued as alter ego of a state, and the assets of Air India were seized. So this is another risk, if your actions, that means if you are a state, your actions could cause global embarrassment to you. So what has happened? See, in US, Air India assets were seized. In French court, 20 Indian properties were seized. And can imagine the embarrassment of Indian government and Indian people there because of this action or inaction, wrong action or inaction, in this case, in enforcing a valid award. So this is another kind of risk which you have in this kind of disputes. And what had been the effect? Ultimately India was compelled to repeal the retrospective tax amendment, and then it refunded INR 7,900 crore to Cairns. So the dispute is closed now, but after so much of embarrassment and time elapsed. Another interesting case from India is the Gujarat Urja case, where the arbitrability of electricity disputes were questioned, and some sort of law was established through this process. So I could see how this doctrine has evolved. In 2008, the Supreme Court, the Electricity Act, a particular clause having special provisions, displaces the Arbitration Act, Section 11, that is the power to appoint the arbitrator. And then only some special regulatory committees can adjudicate this kind of arbitration. So what has done this act is that they have carved out the general arbitration concept from the Arbitration Act, and they brought it into this special act. Then there was another dispute which addresses the tariff disputes, and the exclusive regulatory jurisdiction was given to these authorities. On non-tariff disputes like breaches and termination, in those cases only arbitrations are permitted. And this has been upheld by the Supreme Court of India in 2024. So there are certain kind of dispute which can be addressed by the regulatory, and only non-tariff disputes could be addressed through the normal arbitration route. Last year, a Renew Wind Energy case, the Delhi High Court legislated that even Section 9 interim relief under Arbitration Act is excluded. So look at this in the previous judgment from the Supreme Court, where they say that your breach and termination could be arbitrable. But now this Delhi High Court judgment is saying that even you don't have the power to go to High Court for seeking interim relief. So much so these kind of disputes are different from normal commercial disputes. In UK, it's a very well known place for enforcement. And as I was seeing these 3-4 examples, in almost in all cases, the enforcement attempt has been made in UK. And because the parties believe that the UK is one jurisdiction which are very pro in enforcement of arbitral awards. Don't take it as a guarantee, but that's how the examples suggest. UCOs also went to English court for enforcement. Spanish ECT, they also went to the UK for enforcement. And then Indian case also, I was saying that it is in UK where Air India assets were seized. So that's a very favorable place for enforcement. In Singapore, it's a hub currently for arbitration and developing very nicely in a pro-arbitral jurisdiction. And in UCOS, it rejected the immunity. In DNJ, DOA, it's an anonymized award that the ECT has been upheld. In Parcero case, the ICC interim award and FIDIC DAB decision were enforced. So this kind of pro-arbitral decisions have been taken by the courts of Singapore, and that's again a pro-arbitration jurisdiction. What's the practical takeaway from this session, and how you deal with this kind of cases? And I have few suggestions. is that if you, as I was telling, that there is no well-structured dispute resolution clause in this kind of contract and concession agreements, or even in the treaties, they left much to the, on case-to-case basis. And largely it depends whether the treaties have been ratified or it's just a concept note. Um, like India, it has nullified all the valid treaties. Very, very recently, it is deliberating with new treaties with UK and other states. But this kind of scenario may happen where you don't have a well legislated or chartered dispute resolution route. The suggestion is that you have different standard contract form where multi-tier dispute resolution clauses are there. A similar arrangement could be adopted in this, and probably we can find out a well-disciplined route also, because as I was saying, um, it's a kind of fork in the route, and at particular time you have two routes. Say you can seek legal remedies, or you can go for the arbitration route. And if you have picked up one, you can't go to other one. So although those are the concept which has been practiced for long, but something has to be done now to impose some sort of clarity on the users, and especially in the minds of investors. They want clarity and confirmation to ensure some kind of guarantee or de-risk their investment. We can have some specialized arbitration panels. There are very less arbitrators who are expert in this. This pool is required to be widened, and more experts needs to be brought into the panel. So there is I think, a survey report which says that less than 30 arbitrators are dealing with almost all the treaty disputes. The enforcement reforms for sovereign awards are needed, although India has learned from its previous cases, has come up with pro-arbitral decisions, but still more and more actions are required to give confidence in the minds of the investors. So I was talking about this Gujarat Urja doctrine, how through 3 judgments the doctrine has shaped, and so much so of rigidity that even you can't go to court for the interim relief has been legislated now. So this kind of rigidity is not good for pro-investment environment. Then proactive contractual protections are expected. Some sort of stabilization clauses are required. Protection to investment treaty is another key area that largely depends on the geopolitical equations. But yes, between the political risk and commercial risk, and then only this kind of businesses will grow. Seat selection in investment friendly jurisdiction. This, I think, parties are doing cleverly now. They are picking Singapore, London, and seats like this for their pro-arbitral and pro-enforcement approaches. Multi-tier dispute resolution, I was just suggesting. The Indian Dabol and Khan case demonstrated the consequence of inadequate contractual arguments, where I have said that the contractual provisions were contradictory, the enforcement mechanism was defective. So all those led to prolonged disputes. If you have clear contractual framework, probably these kind of disputes could be minimized. Then cross-disciplinary practitioners dialogues like this, the way we are doing it today, where participants from different jurisdictions have joined, are very, very helpful. and where we can discuss this different kind of EPC contract for renewable from oil and gas sector and all other energy sectors. Is this kind of exchanges will definitely mature the investment environment. So I have come to my last slide, and the takeaway for this session is the getting the dispute resolution architecture right is not merely a technical matter of procedural design. It is a precondition for the mobilization of the trillions of dollars that the global economic transition demands. You could see the amount blocked in this kind of dispute, and for the time, you just work out the time value of these blocked money. See how much the global GDP is under stress because of these disputes. So the point is, energy disputes are not merely bigger commercial disputes. They are a fundamentally different category that engages the relationship between sovereign state and investment, between regulatory power and contractual certainty. Getting the dispute resolution right is, I think, the key takeaway of this session. Thank you very much, and over to you, Madeline.
Thank you. Thank you once again for your presentation and that of Mr. Dandy's. Those are both. Yes.
Yeah, Madeline, I think your voice is not clear to me. Is it me only, or is to others also?
To others as well.
Am I audible now?
Slightly better, yes, please.
Okay, thank you very much. I will keep my camera off so that we are able to continue and move on from these presentations where we've had a deep dive on both the mining disputes and the energy disputes sectors in Indonesia, and we've seen from a more global perspective from Mr. Ajit with regards